Welcome to War Story Wednesdays. Today I want to talk about the case of the Gnarly Neighbors. Let's pretend that you find that beautiful house on the end of a cul-de-sac in a bucolic subdivision, and the birds are chirping in the trees, and the wind is blowing, and it's just gorgeous. And you buy it up and you're happy as hell. Right up until about a week later, and you hear this tree chipping noise, this screech and grind that goes on all day long, followed by the neighborhood basketball game. And of course the loud music with the barbecue. And then you start to sniff in that hot summer day, and you smell tar pit smell. Well, it turns out that their machines use oil, and they don't want to pay the price of clean disposal of the oil, so they pour it on the roof and hope it'll just evaporate away. Thanks. The seller, well, knew about this stuff. And on that transfer disclosure statement where it asks, are you aware of any neighborhood noise or problems or nuisances? The seller marked, no. Really? The Court of Appeals described these folks as overtly hostile neighbors who enjoyed tormenting the neighborhood. It had been going on for years. Did the real estate broker, did the agent, did the seller, did anybody have an obligation to disclose the fact of the crappy neighbors? Now, think about it. The listing agent has an obligation to try to maximize the price that the seller can get for the real estate. If you disclose the nasty neighbors, the value is going to go down the toilet. If you, well, don't disclose the nasty neighbors, the value might match the rest of the stuff in the neighborhood. What are you supposed to do? You're supposed to disclose. The Court of Appeal talked about the value of a property, the intrinsic value of a property. Like where you can say George Washington slept here. That increases the value. It's subjective. Nasty neighbors decrease the value of a property. It's subjective too. But both of those are material facts that must be disclosed. The interesting thing about this case was the court granted damages, the decrease in value of the real estate because of the neighbors being there. And then the court also issued an injunction requiring the bad neighbors to behave themselves. And the bad neighbors appealed. They asked, how come it is that you're going to subject us to paying damages for a decrease in value, but once, of course, we comply with the we must behave order, there's no longer a decrease in value. So the seller's going to get a windfall. We're going to have to behave, and they're going to get $24,000 of our money. And the Court of Appeal agreed with them and said, you're right, it's a double recovery, and you can't have that. And then the Court of Appeal said, but you know, the trial court never ruled on the amount of damages for the emotional distress that you caused the buyers, and sent the case back to the trial court for further review on the amount of damages for emotional distress. One can only imagine if the emotional distress damages were more than the decrease in value damages. So, what do you learn from this one? You learn that sometimes no good deed goes unpunished. You have to disclose the fact that you would really prefer not to, because you know it's going to make a more difficult sale. If you don't disclose it, you'll end up in court.